am on the offensive weapon. That seems to me the same issues that are causing some concern about the directed verdict motion, why it doesn't apply to the jury instruction also. It seems to leave this so open they could decide that the act of dismemberment, the saw, was the weapon used, but that's not really in dispute. I
don't think so. I think the ME pretty clearly testified that those were post-mortem.
The state must prove that the defendant assaulted another person with an offensive weapon
and caused the death.
actually injured somebody.
I want to change this.
There's no display of anything to the jury. How is there any manner in which it was used? There's just no evidence of that at all. The character or capabilities of the weapon?
I agree, which I expressed during my discussions with Mr. Fawcett about the directed verdict motion, which is, like I said, even assume for a moment that I'm like, okay, it goes to the jury. There's literally no evidence of a weapon. I understand the state's argument when we were having the directed verdict discussion was, well, she died in a way where we've presented facts that, could lead, a reasonable inference could be drawn from those facts that she died by homicide. And so then you're, I guess, and I agree with that, right? Which is why I denied the motion for directed verdict on the murder charge. On the murder, the felony murder, secondary, with the underlying felony of aggravated assault, that's what I'm still struggling with for purposes of instructing the jury as well, which is, how can a jury make a reasonable inference that a weapon was offensive if there's literally no evidence of a weapon? And I think I understand the state's best argument is that a weapon in the very broadest sense had to have been used to accomplish the death. Even if that weapon was, I think your example was poison or something.
Right, and not only that, but I think getting back to the root of the evidence that came out, the reason why we aren't able to make those determinations is because the state in which the body was disposed of. And ultimately, I don't know how that's not akin to essentially not the report would have that intent, but rewarding the defendant for doing a good job, making it difficult to make that determination. I think that there are facts and evidence. The judges, Your Honor, is going to give the jury a definition of offensive weapon, and it's up for the state to convince the jury that there is an object or enough facts and evidence that the jury can make those reasonable inferences that an object was used and that it fits that category that the judge is going to define as to what an offensive weapon is. I think that there is testimony from Dr. Gilbo, Dr. Terry, the investigator Miller, not just as the photographs, but the injuries, the manner in which they believe that the body was dropped off and murdered at a different location, that it wasn't sacked up at that location. I think all the facts in this case not just point to a homicide, but a homicide. We never said that she was killed with a saw, although that is still a possibility. She could have been. But we don't have the parts of her body that are necessary to make those determinations. And we don't have them because the defendant disposed of those parts. And I think that the jury has enough facts before it to make all those reasonable, common sense, logical deductions.
Mr. McDermott?
Hey, Your Honor, the state has to prove its case beyond a reasonable doubt from evidence, not from a lack of evidence. What he's arguing for is, court, please allow me some leeway so that I can prove this without any evidence. And if you don't, you're giving a windfall to the defendant because allegedly he hid the body really well and didn't leave us any evidence. That's not how this works. There's got to be evidence.
Well,
And you can't just say, we'll leave it an open door so that we can let them assume any possibility, like poison, et cetera. That is directly contrary to how this is supposed to work.
Well, it seems as if I have some additional homework to do tonight, but I already did because I took it under advisement.